Good afternoon, everyone. Welcome to FirstService Residential's Georgia Legislative Update webinar. We'll give everyone another minute or two because I see people are still joining, and then we'll get started. Still see the numbers going up. All right, let's get started. My name is Mara Jockers. I'm the Vice President and General Counsel for FirstService Residential South Region, and I'm pleased to be moderating today's webinar. We'd like to welcome our two special guest speakers, Lanier Coulter, attorney at Coulter and Sierra, and Joe Larkin, partner at Luter, Larkin and Hunter, two leading Georgia attorneys in condominium and community association law. Welcome to both of you.
Happy to be here, Mara.
Yes, thanks for hosting this.
With Georgia's 2026 legislative session now concluding, condos, POAs, and HOA boards across the state are beginning to assess what was discussed, what passed, and what may impact their communities moving forward. Today's session is designed to provide a clear, consolidated overview of the legislative activity most relevant to community associations, along with perspective from professionals who are closely involved in this space. We are recording today's webinar, and it will be made available on our website following this session. If you have questions throughout the webinar, please submit them through the Q&A feature within the Zoom, and we will answer as many as time allows. Our team will follow up with any remaining questions after the webinar. Please note that the information shared today is for general information purposes only and should not be considered legal advice. We encourage you to consult your own association's legal counsel before making any decisions for your community. And once again, thank you for joining us. Now let's get started. So let's start with the legislative environment in general. Lanier, can you kind of walk us through how the legislative environment in Georgia has evolved over the past few years?
Sure. I would say even 10 years ago, we didn't have a lot of legislation in Georgia. We had a couple of statutes that already were on the books from the 70s and the 90s, and HOAs weren't even covered really under Georgia statutes. And then certainly the uptick has occurred over the last decade, and post 2020, there's been a lot of legislation, a lot of session years. We've seen 8, 9 bills of all different varieties coming out of the woodwork. And up until this year, by and large, we kept those bills from becoming law. But the hot topic of the day, Senate Bill 406, made it through this time around. So the environment has switched from one where they would reach out to us, confer with us on legislation, to one where they this year just were going to pass whatever they wanted to pass and didn't really care about our input as far as the Community Association Institute and the lobbyist on our end.
Do you have any thoughts on why this started happening back in 2020?
I think the real push it was frankly a lot of misinformation on rogue HOAs. There's this, they hear about foreclosures happening for dollars and all types of things, and those aren't Georgia situations. We have a judicial foreclosure process here. It's long, but these stories sell, and unfortunately, HOAs are a common enemy to hate on the right and the left. And if you look at how these bills came out of the House and Senate, there were only a couple people that voted no on either side of the aisle.
Interesting. So, Joe, what were they really trying to address with these bills? Are there any issues that really need to be looked at?
Well, if you ask me, my camera keeps freezing. I'm sorry about that, guys. If you ask me, I don't know what issues they were actually solving by passing SB 406. I don't know why my camera doesn't work, and I'm so sorry. But I think if you were to talk to Senator Brass, the man behind the scenes pushing all the buttons, he had a perception, perhaps his constituency saw uh, an unfairness on the side of the associations. And in truth, a lot of the laws are heavily skewed in favor of community associations in Georgia. And, I think on a practical level, it makes sense. It's been that way for decades. The laws were set up in such a way, and HOA is funded solely by its membership. So every dollar it spends comes from you and your neighbors. And therefore, if you're not one of the ones who's doing the right thing, complying with your documents, paying assessments on time, it seems unfair practically and fundamentally for the ones who are following the rules to have to subsidize the HOA in order to make you comply with the rules you agreed to when you moved in the first place. That's always been the way it was. But as we all know in this industry, the loudest ones tend to be the ones who are violating everything, being what from their perspective anyway, attacked by their association. So they're the ones rattling all the cages of the legislature, specifically Matt Brass and Donzella. And there was a perceived unfairness there. So they were trying to balance, I think, by calling it the Homeowners Bill of Rights, they were trying to protect those who are, at least from their perspective, being attacked by their associations. And they're doing that by, trying to push some transparency, reporting requirements, financial reporting, operational things. And they're also trying to balance the association's ability to recover its attorney's fees and collect unpaid assessments. So, I think that's what they were trying to address, but ultimately the practical effect of it is, in my opinion, at least at this early stage, is going to be very more detrimental to those who are doing the right thing from the beginning. And we can get into that in a lot more detail coming up. I think that was the practical drive behind it, to give homeowners their rights, and the HOA, the rogue HOAs, put them in check.
Sure. So it sounds like some good intent there, and we'll get into the Bill of Rights a little bit more. So just generally, what came out of this session? We know SB 406 passed, and Lanier, what are like the key themes that came out of this session that we should be aware of?
Well, I think Joe kind of hit on there. The key themes were regulation and oversight of HOA, hands down. Regulation and oversight of how we conduct, how we operate the associations. There's now, in broad strokes, there's now going to be this review process through the Secretary of State, this registration process through the Secretary of State. There's going to be tweaks to how certain associations send their notices, tweaks to how long it now will take to even initiate foreclosure. And we can talk about the Bill of Rights later on, but ironically, the Bill of Rights, the name of the whole thing, is a collective of laws that by and large were already on the books, put in one place. So, but the themes were definitely oversight and regulation, hands down.
And that's how I read it as well. So there are a lot of things that are new for these associations now. And what should they focus on first?
Well, I don't want to step too much on what Lanier is saying, but there's really two dates that are relevant now. July 1st is when, and again, we'll get into detail on this later, but the July 1st is when the attorney's fees provision becomes effective. And that's really just for POA neighborhoods. At least that's our interpretation so far. The law was, respectfully, terribly drafted. It's confusing even to professionals in this industry, but I don't know all of the answers yet. A lot of this might have to be played out through, through the judicial system and through the Secretary of State. But for now, I think boards should focus on, at least I've been advising my boards to try to jump on their problematic homeowners now. If you have, I can regale you with a myriad stories of some of the worst actors in the state. They always seem to land on my desk, haunted houses and grass to the windows and shingles flying off. The bad ones, the ones that you do not want to see anymore in your neighborhood, now is the time. So really try to focus your enforcement efforts now before the second, by the way, I glossed over this. The second important date is January 1st of next year. That's when all of the registration, all of the oversight, and the Secretary of State's being injected into all of these disputes, that's when that becomes live. It also will become more difficult for POA communities to foreclose. So, we're kind of hitting the gas on some of the more urgent matters today. I definitely would get with your boards and try to focus on those now. Starting next year, I think foreclosure will be challenging, at least more so than it is now. But compliance-wise, we have some time. And honestly, I don't know what it's going to look like yet. I don't even think the Secretary of State knows what it's going to look like. One of the things that we've talked about internally at our firm is literally reaching out to the Secretary of State and assisting them with this registration process, so that they don't do anything crazy or weird. We want to try to help them through it. But we are going to have to register starting next year. It's an annual requirement. So I do feel that most management companies, if you're a managed community, the management companies will assist with that. It's not optional, in my opinion, although you could hypothetically not register, but by not registering, you lose a lot of your ability to enforce your documents. So the registration process, we have to give the governing documents, the name, address, and officers of the association, financial statements from the prior year. And again, I've not seen any forms, so I don't even know exactly what that looks like, but these are all records that the association maintains anyway. It should be fairly simple to just submit them prior to December 31. And honestly, the other weird thing you have to keep track of, because we do have boards that shift a lot. So if there's an officer or a director that resigns or is removed, you have to update it within 30 days. But all of that doesn't really come into effect until next year. So my advice for today is really look at all your bad accounts and try to get them going as quickly as humanly possible.
Sounds like a good advice, Joe. And I definitely want to hear your haunted house story after this, because of all the things I've seen, I have not had a haunted house yet. So
I think it was more just aesthetics, Mara. I don't know if there was ghosts living there, but that's what all the neighbors called it.
That's very funny. So you really kind of walked us through this new registration process, but what kind of associations need to register, and how frequently are they going to have to do this?
Well, they'll have to register annually. Joe pointed out there's certain information you have to update every 30 days. I think from the planning process, implementation process, I agree with Joe wholeheartedly. Look at who you've got your problem children, get them in the pipeline now. Don't wait, as far as whether it's covenant enforcement or collections. But I think on the implementation side, on the other end of it, I think associations that maybe have, for lack of a better way to say it, kind of flown by the seat of their pants on things like enforcement and everything else. Unfortunately, I think you're going to want pretty clear policies now on collections, on covenant enforcement, if you don't have those. And I would tell boards to spend the remainder of this year documenting those things very well, because I expect, while it's a complete unknown how the Secretary of State is going to handle these hearings, but if you find yourself at a hearing, I feel like you're going to be in a way better place to have a policy that you have shared and promulgated with the community before you took steps and ended up in whatever forum the Secretary of State puts you in for this hearing. Having those procedures in place will be, in my mind, pretty important for associations.
Yeah, I agree with that. Always good to have written policies in place. So let's jump into some of the new record and data requirements that have come along with this legislation. I know one of them is very big, maintaining 10 years of records. What has this looked like historically, and what do you anticipate how this will look going forward?
Okay, yeah, 10 years of records is now the standard. And we've been asked this, Lanier and I have been practicing for about the same amount of time. And my answer to that question prior to this was 7 years, because that's what the IRS required. Now we have to add another 3. And I honestly, I probably have a lot of self-managed. I know I have a lot of self-managed neighborhoods that don't do the best record keeping. They've got a banker's box in someone's basement, and we had a lot of debate a couple days ago amongst the attorneys at our firm. Is this retroactive? What happens if you've not kept 10 years of records? I don't think it's even constitutional for them to enforce this retroactively. But hopefully, if you've been managed professionally, you should have at least 7 years of records, and maybe more. So I don't know if there's a real practical effect on most well-managed communities, even the self-managed ones that do the right thing and keep all their books and records. But I think a lot of that information, a lot of that data exists already, and I think most communities probably have that. They might have deleted everything older than 7 years up to this point, but obviously going forward, they're just going to have to keep it, and hopefully it's all housed safely on management company servers somewhere.
And are there any reasonableness to this? Because I can foresee a unit owner showing up and saying, I want all of your records for the past 10 years. Anything in the documents and association documents that might help with some of these things?
Well, I think that's a fundamental question that Joe's firm, our firm, we're all debating internally. Joe hit on some constitutional. I think there's 3 or 4 different constitutional issues. I know Joe agrees with the bill on some of the rewriting of existing contracts. But from the whole documents, it's not every email, every correspondence. It's really geared towards financials that it wants the association to have for 10 years, if, in the weeds of it. And unfortunately, Joe and I are going to keep saying this, the unknown is we don't know who's going to have this role, this referee title, all these positions at the Secretary of State. But, who needs to register is frankly anyone that wants to enforce their documents. A strict reading of this, you can't even put a lien out for outstanding assessments without registering with the Secretary of State. And if we have the wrong person in the Secretary of State, I think what we're all dancing around because it's unknown is they could find a way to pretty much flag almost every association if they really wanted to do it because of that 10-year requirement, as well as some other things that are in the registration process. And there's a whole hearing process to appeal if you get in trouble with the Secretary of State and all those things to make it right. But we don't know how severe they're going to be, how strict they're going to be at this juncture. But if you want to enforce, you need to register.
Yeah, that they definitely made clear, and I could ask you a whole lot of other operational questions, but I know we're all just guessing at this point. And just to follow up on the registration quickly, First Service will be assisting associations with the registration process, of course, looking to the guidance of you all because it's going to be new for everybody and it's going to be interesting.
Mara, if I can real quick, I know Joe hit on updating in 30 days. It's also updating any amendment that you do of what they view as material amendment. And so it begs questions across the board on so many different things. Is a developer, every time they annex in more property, making a material amendment? Certainly a pretty solid argument that they are. So I think it's going to create havoc, not just on boards and HOAs in the traditional sense. It's going to impact developers. It's going to be a far-reaching impact here.
And so it's going to be annually, every 30 days, new documents. Going to be an adjustment, that's for sure.
I'm wondering, Lanier, what are your thoughts on, do you think a swap of limited common elements would be material?
Hey, it is to me if I'm the one getting a new parking spot, right? I mean,
oh my.
It's going to be, these are the unanswered questions. So, and we're all going to, I think from the lawyer's perspective, we're all, I don't want to speak for Joe, but I know Joe, we're going to be like, well, yeah, file it. Why would you run the risk?
Might as well just file it.
Yeah.
Let's switch gears to another important change with the collections and payment application. But before we jump into that, can you, either of you, distinguish for the audience, HOA versus POA, so we're clear about what we're talking about.
Lanier, do you want to do it or?
Yeah, that's fine. So virtually every community association that's not a condominium in the state of Georgia is just a general HOA at inception. It's very few developers that submit a community to the Georgia Property Owners Association Act Day one. It's a different statute. It was supposedly similar to the Condominium Act. It's way shorter. But most associations voluntarily follow whatever procedures in their documents, a board amendment or an association amendment to submit to the POA. That's the most common way it occurs. And the most, common reason why it occurs is because of a case in Georgia where if you want to make your documents more restrictive, for example, the classic one, add a leasing restriction, you need to submit to POA in order for it to be binding on everybody. So why people historically have done it is because they want to amend something else. Also, it has statutory liens in it. So before that case came down, a lot of communities submitted to the POA because you don't have to file a paper lien in the land records anymore. You have a statutory lien and the burden flips to a closing firm to call on a seller refinance. Anything I missed there, Joe?
Yeah, that's perfect. It makes payment of assessments mandatory, which is why most developers would never submit to it. They would then have to pay assessments on their vacant lots unless they gave up the right to vote. Statutory, it gives you the right to foreclose. I mean, without the POA, foreclosure for a common law homeowners association is extremely challenging. You could hypothetically do it. I think one of our colleagues has before, just seeking from a court of equity, just out of fairness, the ability to foreclose the association's lien. But submitting to the POA gave you the right to amend your documents and have it apply to all. It gave you a statutory lien. It gives you the right to foreclose, and it also gives you statutory background and backbone to a lot of the things that you had contractually anyway. So it really didn't change much from an operational standpoint, but it gave you a little bit extra oomph in court, so to speak.
And it seems like the legislature is pushing to have all these HOAs become POAs, correct?
There was another bill that didn't pass by Donzella, who Joe mentioned earlier. She was pushing a bill essentially to make it easy for any community to opt into the POA. So yes, you're right, Mara. They're wanting us there because then it's easier to regulate and all of this
Sure,
comes
so
back
you have to register and you need to be under the statute, and that's
Yep.
for regulation purposes. So when I read this, and I don't have the knowledge of Georgia law that you all do, but I saw there was discussions of fees, dues, assessments, and it's not always clear what they're referring to, at least for me. Can you kind of talk through that a little bit?
I gladly
I'm
give that
laughing
to you,
because
Joe.
we had the same talk. Yeah. Lanier, I don't know if you want to tackle that. Yeah.
Look, I think the big takeaway for everybody, and I'll let Joe add more to this, but they went through trying to define these different terms because their clear goal was to make it where for a community that can foreclose a condo or a POA, although they miss condo, a whole nother discussion there, but for a POA to foreclose, they wanted to make it clear it can only be for assessments. They had this knowledge, belief that I believe the way it was articulated was management companies and or lawyers would run up the fees to foreclose on people that owed no assessments. And, our firm, I feel like Joe's firm, there's a lot of discussion with any community that's trying to foreclose simply for fines. It doesn't look good. We're smart enough to know if we got to go to court, do you really want to go just for fines or just for attorney's fees or cost or anything like that? So it was already, in my opinion, kind of a self-regulated system because you got to go in front of these judges all the time. You don't want to be asking for foreclosure solely for fines or attorney's fees. But that was the driving force, but behind the attempt to define it. And the outcome was for a POA on this statute to foreclose, it's got to be assessments only. And when you talk about owing $4,000 out of a HOA, it's not there. And my law partner has kidded around about this. She said the one thing we should tell every community is, hey, your annual dues need to be $4,000. And nobody wants to hear it, but that's what they've essentially done is they've forced communities to think about, do we need to drive up our assessments to deal with the regulation and to get there? And then the other portion of it is, do we need to tell every condo and townhome that they can no longer do installments? They have to accelerate their entire balance January 1. So instead of $300 a month for 12 months, you owe $3,600 on day one. And then just nicely tell people, but hey, out of the kindness of our heart, even though all 3,600 is on your ledger, out of the kindness of our heart, we'll just go ahead and give you a monthly payment of $300 a month. And we don't know how a court will interpret that or the Secretary of State will interpret that, but that's what they're forcing. They're forcing us to play games back.
Mhm.
So.
And this is mostly related to POAs, right? Condos are
Yeah.
not in this, so you can
I
still
think
do business as usual condo wise.
I know Joe's been part of a lot of discussions, so I'll make this real quick, but I think what we wrestle with internally, and I would imagine his firm is, our judges, I know everybody wants to believe every judge is fully knowledgeable of every bit of the law. They're not. So our judge is going to look and treat all community associations the same. And I would tell you, based on my experience, there are some judges in this state that will. They will, it won't matter if I'm standing there saying, this is a condominium, we can do this. In the right situation, if the judge wants to rule against us, they will simply say, I think the intent was for everybody. I think it was all communities.
Sure. And could you see the legislature in the future saying, well, now that we're doing this on the POA side, let's codify it on the condo side as well? As a possibility.
It's possible. Lanier and I were on a call with the Georgia Legislative Action Committee, and Lanier said something that resonated with me. We're kind of hoping, at least, and I share Lanier's hope, that when they see how complex and administrative and it's just going to be a nightmare, I think it's going to clog the court systems too, just because of the attorney's fees provision. Maybe they will repeal or modify this or tone it down in the coming years as opposed to expanding upon it. That's my hope. I think Lanier shares it, but yeah, it is absolute merit. It's possible. It is possible that they will take this and expand it to condos and non-POA HOAs. I mean, it's absolutely possible.
Right.
And I have that hope, Joe, but I will add Senator Brass openly talked about when he presented the bill on the floor that this was the start.
No, we're just beginning. Great.
There'll be a rewrite next year called 102. So what concerns do you have, if any, around changing that notice of intent to lien from a 30-day notice to a 60-day notice? And how does that play with the attorney's fee notice that's now going to be required for POAs?
Lanier, I think that was you?
Yeah, I mean,
I'm sorry, I'm not saying Lanier or Joe. I'm just putting it out there. So let's say Lanier. How about
I can handle it too, but it's okay.
Well, I'm not overly concerned about the change from 30 to 60 days. We already have to comply with the Regulation F of the FDCPA and do a 40-day notice. And then the 30-day notice that existed now is going to be 60. So from a practical side, I don't think we're concerned about the 30 to 60. I think the message to communities goes back to that policy. Your collection policy probably needs to be tweaked. Again, you're being forced not to be as nice as maybe you would have been. What was a 60, 90, even 120 day before we turn it over to lawyers, you're probably going to see, can we back it up 30 days? Because now everything takes longer. On your attorney fee piece, our firm has always sent certified letters when we're talking about suing someone. I think the complication becomes that the association or its agent, the management company, now is supposed to send a certified letter warning that if you don't cure it within 30 days, it's going to go to legal. There could be attorney's fees, all those other things that you could be liable for. And I think that's just going to be, I think the management companies candidly will work through that, figure it out on their last late letter, their last enforcement letter. I think they'll figure it out. It's got to be certified. I think what unfortunately we're going to see is a lot of self-managed communities struggling over the next 12 to 24 months and hearing when they do get a hold of Joe or me, sorry, you didn't do this right. We got to start over.
Right? I'm sure that will definitely happen a few times. And now it seems so the very earliest that you could potentially move forward with a lien is 90 days. That if you do a 60 and a 30, or just wondering, because those that really need the funds to keep the association running, how much of a delay does it create?
Well, one thing I would keep in mind is they drafted it wrong in POA only. So you already have a statutory.
It's already
lien.
there. Yeah.
Yeah. So that, again, they just don't understand the intricacies of our laws. But the communities they're saying can't foreclose, can't lien, are the communities that have a statutory lien the day you owe money. So
Yeah, the
that's why I'm
instant.
not as concerned about that timing. Go ahead, Joe. Sorry.
Yeah, no, Lanier's answer is correct. The lien exists. It exists the moment you owe assessments or fines or anything. The problem, of course, now is the delay. It's compounding our problem. Recording a lien, honestly, may not even move the needle for the worst actors. A lot of them will let that lien ride as long as they can. I think there's maybe the only positive aspect of this law is that now the lien lasts for 6 years, so it gives us additional time. But whereas before it was 4. But yeah, the delay is the issue. That's where all this time that's going by and all the homeowners that are yelling about why is this person owe so much? Now we're just adding more time to the mix.
Right.
And then they can hypothetically, not even hypothetically, they can legally almost pause our actions by filing a complaint with the Secretary of State, which causes even further delay.
Yeah.
And the wording of that is just wild. So the practical effects are really just dilatory, in my opinion,
Just
not
see
necessarily practical.
the homeowners receive a letter that they're delinquent. What do? Do they go file a complaint and try to pause that?
I think there's going to be plenty that we already probably know in our respective communities that
I
are going
do.
to game the system. And I don't want to jump the gun, but there's now a provision where we have to take a payment. And if you don't think there's not going to be players that put accord and satisfaction on a check for $5 or whatever when they owe 50,000 and try to say you can't reject it. I mean, statutorily, they have said we must accept any payment, period. There's no carve outs, there's no exceptions for someone with a disputed debt, nothing. So I'm going to buy a condo and pay $1.
So Joe, let's talk about those foreclosure threshold changes. And what do you see the effect of that being on our associations?
Lanier mentioned this before, and I'm going to, yes, before we advise our clients to foreclose on someone, it almost always is a very extreme case. At our firm, we do foreclosures here. It's not the bulk, or even it's in the small minority of the things that we actually do. I mean, maybe 1 or 2 a month on the heaviest of months. The problem here, specifically with POAs, because that's the one that was hit the hardest, is that they have to owe $4,000 instead of $2,000, or 12 months of regular assessments, but not less than 2,000. So to Lanier's point earlier, he mentioned why not just everybody start charging $4,000 a year? Hypothetically, you could make that $2,000 per year. It's the statutory minimum to foreclose in a POA, but it does have to be that in a 12-month time frame. There's also this payment application issue. It's very problematic, and Lanier touched on it. I will expand a little. There's a lot of declarations out there, the ones that our firms draft, Lanier's, our competitors too. The ones that do this professionally for a living will put within the declaration payment application, so that when somebody makes a partial payment or submits a check, that we can apply it to fines first and then attorney's fees and then however it might be worded, but usually then it goes to the oldest late fees, then interest, then oldest assessments, and then to the newest.
Right.
The legislature through this SB 406 has basically turned that all the way upside down. So now payment goes first towards regular assessments and then to special assessments, then to specific assessments, and then to fines and fees at the very end. And then knowing that we have to foreclose based upon dues or assessments only, if they're making payments and we apply them first to those unpaid assessments, we may never cross that line. And they could just sit there and ride the wave with these fines on their account for forever. And I mentioned this haunted house that was actually in a neighborhood in Forsyth. The fines in that case got very high, and Forsyth isn't really favorable to associations. And the facts in that case were the man had a septic tank that was bubbling up into his backyard and then flowing into a stormwater facility, and it was Forsyth went after him and couldn't get him to do it. And then we did. It took forever. And that's how I got the judge to agree that this man needs to go. But he hypothetically, under this new law, he could pay his assessments, and I might never get that right. And it's going to be challenging. I think it's really going to be challenging to hit that dollar threshold, given the new payment application language in the statute.
So it seems these ongoing collections where they pay just enough to keep from hitting the threshold will cost the associations money in terms of attorney's fees and things of that nature, right? Because you'll never be able to get to the point of recoupment for some of these.
Yeah, I mean, I think one of the ironies here is regulation typically always leads to more attorney's fees and time, while at the same time, they're trying to statutorily make it harder to get your attorney's fees that you are forced to spend because of the procedures they've put in place. And I think, that's one of the unanswered questions here. If you want your attorney to attend the Secretary of State hearing, I think we have to be candid that you may have zero claim to those attorney's fees, which typically associations like their lawyers at this type of tribunal to make sure they don't say anything wrong. So.
Yeah, and just to put a point on that as well, specifically with regard to POAs, there now has to be a judicial determination that the attorney's fees that are assessed to the homeowner are reasonable, which means that we have to sue. I'm going to have to file lawsuits to collect attorney's fees for POA communities, and I think that's going to be a very interesting consequence to this bill. It's going to be a lot of litigation where a lot of the times we could resolve them well before. So if we have a homeowner that's outright refusing to pay attorney's fees, we're going to have to file a suit.
Is there really even an issue with unit owners being taken advantage of or excessive foreclosures in Georgia that you're aware of?
So
if you ask me, I'd say no, but
I'm asking.
Yeah, the little old lady who is on a fixed income, I could not look at you, Mara, with a straight face and say I've never done that, because I actually have. It was a long, long time ago at a condominium, and she could not afford it. And my board has a fiduciary duty to act in the best interest of the corporation, and you will run into those. They are 1 in a million. I mean, it's most of the foreclosures are the worst actors. Lanier, do you want to add to that? I don't think anyone's predatory in this field.
This bill happened this year, but it's been talked about for the last couple of sessions. And so we actually polled the major firms as part of the legislative effort to say foreclosures aren't a big deal. And at that time, I know Joe indicated kind of how his firm is. Most of the firms truly foreclosing, actually having to evict the person out of there, it doesn't even happen 10 times a year at any of these firms. Some of the firms, it was 1 or 2 a year of the major firms, in our area. So it's just not that common. The threat absolutely is used because every association needs their funds in order to operate. So the threat is certainly used, but the real, hey, we've got a foreclosure, we're going to evict the old owner out of there, is a very rare thing in Georgia.
So how does the legislature have this misperception or seem to have this misperception?
I think Joe hit on it earlier. There's some squeaky wheels that scream a lot, and these are stories that sell. But go ahead, Joe.
Yeah, there were a couple of news stories out there. I recall them being forwarded amongst the attorneys at all the firms about an association foreclosing on a woman who owed $2. It's legally impossible. They were sensationalized. They were causing a big stir. And in truth, if we're being honest with ourselves, HOAs have a bit of a bad reputation for being the Karens, I guess. I don't know what else to call them, but for enforcing rules, the rules that everyone, by the way, agreed upon when they moved into their neighborhood. So yes, they are enforcing those. They have to. So there was a bit of a bad reputation, I think, from a very few number of cases with extreme facts. And those cases, I would argue, although my firm wasn't the one that handled the one that I'm talking about, the one that made the news, those cases are rare, and that person was lying. They were not telling the truth. You cannot foreclose for $2. It's just not possible.
Right.
So yeah, I mean it's the loudest people are the ones that are upset with their homeowners associations, and the quietest communities are operating well, and everyone's doing the right thing.
And
I will say, just piggybacking on what Joe said there were some bad actors. There are some bad actors, and to me, the bad actors I'm aware of, and I'll give kudos to Joe's firm. We had a really bad actor that we fired, and I strategically put the email of why I fired them on top. And an attorney from Joe's office called after they inherited the client and said, "Is this for real?" I said, "Yeah." They said, "We're firing them today." And so you guys, you didn't even take them in, Joe. I think we self-regulate as an industry for these bad actors, but what they've done won't fix the problems that most of these people were complaining about at the session. That's the surprising thing, that the bill doesn't actually deal with what a lot of them were complaining about. So
no, we've talked about these bad actors a bit, and we've talked about this complaint process for the Secretary of State. Just practically, how do you see this working? What kind of complaints can be made with the Secretary of State? How do you see this working? Joe.
Okay, I have the privilege of representing some of the most snake-bitten communities in Georgia, with some of the craziest human beings I've ever encountered. So I have a feeling that this is going to affect me detrimentally, more so than many. The practical effect is, if they file a complaint with the Secretary of State, is that it stays all enforcement actions. And I don't know what that's going to look like on the other side yet, Mara. I don't. I wish I did, but I don't. And we're going to have to go in front of some group of unknown humans, or maybe one. And what I'm envisioning is a mediation or some type of dispute resolution process. And the language within the statute, and I'm trying to pull it up here on the back end because it's interesting. It almost gives the Secretary of State the right to consider. I'll give you an example. It's anecdotal, but I'll give you an example. I've got a gentleman who owns a townhome unit in Stone Mountain, who has sued the association, his management company, and his former management company, seeking $2 million. Because we asked him to remove a garden that he planted on the common elements. I don't know where he got that number, but there's this statute seems to give him some sort of standing to seek that amount and have the Secretary of State rule upon it, whether that's reasonable or not. So it's the implications, in my opinion, the worst implication is that we have to stay everything and go through this process. And as Lanier mentioned, It's going to add cost, it's going to add time, it's going to add a lot of headache, and there's potentially even bad outcomes that could result, because I don't know who's going to be arbitrating these things. And if they're well versed in HOA or condo law, and if they're just going to be, like, again, anecdotal, we don't sue in magistrate court because we find those judges are more of a split the baby, and the outcomes don't matter. So we try to stick with judges who have to enforce the actual law. And that's my concern. I don't know what's going to result from these complaints.
I wasn't clear if you're trying to enforce something against a resident and what they're doing is dangerous or could cause damage to common areas or harmful to others. Do you have to say that enforcement? And if you do you come in and fix it yourself? Like what happens there?
Well, I think there will be a uptick in self-help where communities can get away with it, but we're in a different time than even 10 years ago where somebody, could come out of the door with a gun in their hand and it's their property on self-help. So, I do think there'll be an uptick in self-help. And I also just want to make it clear, what could go before the Secretary of State is anything a homeowner is willing to gamble $100 on. I don't like the new landscaping could be a hearing before the Secretary of State. And one of the things I could see coming out of this, to kind of Joe's point, if we end up with a bad referee at the Secretary of State or whatever, we're going to call this person. We've talked internally about it, and Joe, maybe you guys have too. Are we going to get to a point where an association could be dragged down to the Secretary of State, could have to either pay their manager or their attorney to come with them, or they can lose $100? I think we're going to get to a point where some condos simply say, hey, here's our response. Here's our $100. We're going to go ahead and appeal. Issue your ruling. We're done. And I think that's going to be a real possibility for some communities to say it's just cheaper to pay the $100 and get to real court for the bad situations.
So practically, what should our communities be doing to prepare for this? We have some time for most things. And what should they be doing? I assume working with you all, but other than that.
Well, I touched on that earlier. I do think
Yes.
now is the time to lay down the law on all of the baddest, the worst of the worst, and try and get something going on them as soon as humanly possible. Because starting next year, all they have to do is pay $100. I'm not even clear whether or not it's at any point, if we've sued them, if they can just stay a lawsuit right there in the middle of it, paying $100, and then just having it shuffle over to the a hearing officer at the Secretary of State's office, delaying things inevitably. What if we've gotten a judgment and we're actually moving to foreclosure? Can they then file it? I think that the best advice now is to try to get all of your problem people handled as quickly as humanly possible. And subsequent to that, I think we're just going to have to see how it plays out. I don't know what's going to happen. We're talking, one of the things that we're going to be doing is meeting with all the law firms coming up and talking about ways to attack this law, because there's a lot of constitutional issues within it. And who's the right plaintiff? Are there multiple plaintiffs? Who's the right defendant? And we're going to be, that's one of the topics that we're going to be discussing. But yeah, we're just going to have to live with it for now. And frankly, Mara, I don't know what it's going to look like when it actually comes into effect. So it's hard for me to advise how to prepare other than just to say jump on things now.
Right.
And we'll be working through it and likely be sending out lots of communication to our clients prior to the beginning of next year on how they should address their budget. And of course, we're going to be doing education with managers too. But it's just so soon that I don't have a lot of detail on practical ways to prepare. Lanier, if you have something, please add. I just don't.
No, I mean, I think, I hit on it earlier. I think it's time to look at your procedures, memorialize your procedures, and get in the habit of sticking with those procedures exactly as you've drafted them, so that you don't have you don't have all the things that now, to Joe's point, we're going to have, frankly, a layperson in all likelihood, not a judge or even an attorney hearing. And, I have some optimism that this is going to be realized to be bad, but I also have some concern that we're not going to live with it till next session. We're going to live with it till at least 2 sessions from now, because if it doesn't start till January, we're not going to have enough examples in the current session of 27 to fend off and tell them you got to tweak this in all likelihood. So I think we got to prepare potentially for 2 years unless there's a constitutional challenge that stays it. And to Joe's point, I'm sure we'll all be blitzing managers and talking through all that as it plays out. But right now, we got to prepare for it. This is going to be the law starting July 1 for one small portion and January 1 for the rest of it.
Well, thank you both for all this information and your thoughts on something that is still a bit vague for all of us to wrap our arms around. I'd like to move to the Q&As, and I do see some questions in the chat. I see a question that says, regarding financials, the law includes bank statements, and there's a cost associated with retrieving those and then blacking out confidential information. Can associations charge when they're producing those records?
I guess my question to Michael, charge who? Now, if you're talking about us providing documents to the Secretary of State, that's now our legal obligation. I don't know. I mean, obviously, if our bank is charging us, that's
about
probably
the
just gonna have to
records
come out of the general operating account. We also have there's a registration fee of $100 per year that is gonna have to be added into budgets. There's obviously going to be a lot of other expenses that come with it. I think budgets next year are going to be very interesting as a result. It's a lot of prediction with unknown consequences. So, if a homeowner is requesting bank account information, they have a right under the nonprofit code to see it, and we can charge for copies of it. But I don't know if we'll be able to assess. Linear, do you have a different opinion on that? I don't know if we'd be.
No, I think the compliance portion, associations are going to have to budget for whatever they need to do to comply. It's just going to be just like you budget now to your $25 registration of the Secretary of State. Well, now on top of that one, you got your $100 for this new program and those fees. I think, we're going to go to a world where communities have to make a tough decision. To your point earlier, they haven't kept 10 years of bank statements. So do we have to go pay for 10 years bank statements, or can we tell the Secretary of State, like, hey, once this thing came out, we started keeping bank statements and here's the ones we have, we'll upload them. It's an unknown, but I don't think we'll be able to bill it back to whatever we incur to comply with the Secretary of State. It's just going to be part of our normal operating budget going forward.
And Betsy asks about the liens, foreclosures include interest, and based on how they're requiring you to apply the assessments, it doesn't really say interest is a part of that, but.
It's definitely assessments, your normal annual assessments. You can't even foreclose on a special assessment. So if a condo specially assessed, and your pro rata portion was $4,000, if you refuse to pay it, we can't foreclose on you for that number.
So all the interest and late charges and things that may have accrued for years will not be included.
Will not.
So there are a few
worded
questions.
Poorly, Mara. It is worded poorly. We don't know. We don't know what is inclusive in the word fees. I mean, you could argue. I think you could maybe argue that if it was fruit from an unpaid assessment, maybe we can include it. But Lanier's probably right. It's most likely just the principal balance.
Right.
I think we will ask. I think right now, and Joe mentioned we're all going to have a meeting as law firms. I think we'll ask in a foreclosure lawsuit for everything to be part of the foreclosure judgment, but we've got to be able to show the judge that $4,000 of it, or on the sliding scale, the 12 months, is pure assessments. They might owe 10,000 total, but we've got to show at a minimum that 4,000 or whatever is base assessments. We're still going to ask for
documents entitled the association the right to assess interest for late payments, then you would try to get it all, which makes sense, and see how that plays out. That makes sense. There are a few questions that are directed to internally for First Service, like what is this process going to look like? How are we going to handle certified mail? And those I'm gonna address offline, because we will be sending communications internally about our new procedures and how that's all going to work. Sam wants to know, what's the path for accounts that do not hit the threshold within 12 months?
if you're a POA, the Property Owners Association Act, the path is to sue somebody just like an HOA. No foreclosure, just sue.
Yep.
But remember, you got to be registered before you can do that.
That's correct.
So you're literally suing for what, breach of governing documents or statement of account or something like that with no foreclosure power.
Correct.
Yeah, and that sort of goes to Sam's other question, which was, what was the goal to limit POAs as HOAs maintain their regular rights under this law? It almost, in a weird way, it almost makes a POA neighborhood more like a common law homeowners association. It would just basically eliminate your right to foreclose until, and for some of our clients, many of them actually, they may never hit that threshold. It might take 4 years of unpaid assessments, 3 plus 4 years to even hit that threshold. And of course, by then we've struggled with not meeting our budgetary obligations. So yeah, it's really going to harm. I think it's going to harm the good guys ultimately.
So this is just for my own knowledge. If you obtain a judgment that is not attached to foreclosure for unpaid assessments, fees, whatever it is, can you then sue to foreclose on that judgment? Is that allowed in Georgia?
So if I had a judgment in an HOA today for $5,000, I could go through the process to levy, is what it is in Georgia. And I think Joe hit on this at a level earlier. The problem there is you have to pay off superior liens and encumbrances to levy. So if you've got a couple $100,000 mortgage, the association has to make a decision. Are we going to front that, pay off the mortgage, levy, and recoup enough money to make this all worthwhile? And most associations just don't have the funds or the ability to do that.
That makes sense. Let's
Yeah,
look at
and to piggyback on Lanier's answer, a lot of my POA neighborhoods, they just do normal collection lawsuits without even seeking foreclosure. And there's many reasons why, but primarily it's because foreclosure is a pretty big gun out there. It's in our arsenal. It's a pretty extreme remedy. So, maybe from that standpoint, a lot of that will not change, but where it's especially problematic is when you have a homeowner that you really are out of options. And the only way to get them into compliance or really to get them to do the right thing is to get rid of them. And that's where we're going to struggle. And thankfully, again, Lanier mentioned it, it's a very small minority of cases. So, it's hopefully won't have that big of a practical effect on the most neighborhoods, I would hope, from a collection standpoint.
All right, I see a question from Heather. It says, if an association sends a violation requiring them to comply and they file a complaint with the state, are we saying that they can't uphold that violation until the state rules on it?
So we're going to have some forced issues pretty quickly play out on things like I think what Heather's getting at is, if the homeowner proceeds, and in her example, potentially building their home in violation, we're going to go to the judges and basically have to file for immediate relief because the Secretary of State, I don't anticipate the Secretary of State moving fast at any level as they implement this program. They have no idea what they're getting into. So I fully expect Joe's firm, my firm, to be filing and pushing the envelope on these type of situations. But these are the factual situations we would want to push the envelope on. These are great facts of they're still building the home, and we've got to at least get an order stopping construction. So that's where I see it going. Go ahead, Joe. Sorry.
Yeah, I agree fully. Yeah, and that's an extreme example. But if somebody starts to pour a foundation and they've not gotten proper approval, or it's different from what the association approved, typically we'd advise our clients, let's go get a TRO. Let's stop this construction in its right now before it gets too far along. Then if they file something with the Secretary of State, our lawsuit is stayed. And what if they continue to build? I just don't see how that outcome is fair. And ultimately could cost everyone a whole lot of money. So we're going to be testing it. We are going to be testing it. And there will be circumstances that require us to, I guess, maybe read between the lines or ignore certain aspects of the new law and see what happens. So, yeah, but he's right. Those are the cases that we want to see. And ultimately they might even end up being plaintiffs in this lawsuit against the Secretary of State or the Attorney General, whoever we decide to eventually sue, to seek clarity or maybe even get aspects of this repealed as being unconstitutional.
And I don't want to get too far in the weeds, but I think there's a pretty easy reading of the stay only applying to collecting any fines or fees. And in this example that Heather's talking about, like I said, for the immediate relief, we're just saying you got to stop construction. So, but the stay prohibits us from doing any more to collect fines or fees. So where that's going to hurt is in a community that needs the money of their assessments, and a whole bunch of homeowners find out about this and file something to stay the collection of their assessments. You know, I could easily see the Secretary of State getting bogged down for 6 months to a year on these type of things in year one. And so I think communities are going to hurt more that need the money and people figure out to play the system.
A couple more questions have popped up. I'm not sure if you all know the answer to this yet, but I think it's a good question. What are you going to recommend for new projects put in their governing documents to try to alleviate some of this?
Lanier, you can hit this one because we haven't even had this discussion at our firm.
Yeah, I mean, it's a hard question right now, but I think it's a good question. So
It's a great question.
Yeah, it's a great question. We've had some tough conversations with a handful of developers already because developers are still going, they're still recording. We know it's going to be the law now. So we're still drafting our declarations with the application of payments. We're still drafting our declarations the way we want it to be. We're still putting our dispute resolution procedures in there. And in all caps at the bottom of the first page, we're wrestling with verbiage, so don't quote me on this, but it's going to say that all parties agree and understand that they're agreeing to the dispute resolution procedures in this contract. They're agreeing to the application of payments in this contract. And we're doing that so that we have, at least in a strong contract state, the ability to say, that's great, they have this statute over here, but we've agreed to something else. And so that's how we're tackling it in a nutshell, is we're openly, blatantly saying, and I said I wouldn't curse on this program, we're blatantly saying, we don't care about your statute, we're going our own way, and everybody's agreeing to do it by purchasing it. So, and I think there's some good cases still in Georgia on that. We're still in the state where when an owner bought and there was a security provision, it held up when a very unfortunate incident happened to that owner. So, and fundamentally here, we're talking about actions against owners. So I still believe they would have to reverse some pretty serious case law in Georgia. We got all kinds of contract case law. It would be a big switch for a court of appeals or a Supreme Court to say, no, it's no longer a contract.
Okay, I see one more question from Sam asking if you use self-help because the delinquent account is in disrepair, so you go in and the association makes that repair. Is there a mechanics lien process they could use? I'm not aware of a process like that, but maybe you all know something.
No, I mean, a materialman's lien is a lot different. I would say in that particular scenario, if we were paying a third party to maintain somebody's yard and then we didn't pay that party to maintain their yard, then they could file a materialman's lien on the owner's lot. But in truth, as we discussed earlier, the association does still have lien rights pursuant to statute. If we go onto someone's property and maintain their lawn, remove weeds, mow their grass, whatever it is, the association pays for that as a common expense. We can put it on their ledger and it will constitute a lien under the POA, even though we can't necessarily record a paper lien for 30
I like
years.
the out of the box thinking though.
No, it's good. I mean, I appreciate that too. I really do.
Yeah, so I think we've answered all of the questions, and we're gonna wrap it up. So I'm gonna thank both of you as our panelists and taking the time to participate in this with me and helping us understand and talk through what it is that we know right now. And here at First Service, our promise is to deliver exceptional service, and we will continue to advocate for all of our associations before policymakers and regulators to protect the interests of the community associations we manage. We're committed to keeping the board members we serve informed to help them make the best decisions for their communities. For more educational materials designed specifically for condominium and community association boards, you can always go to our website, fsresidential.com. Thank you all for your time and have a great day. Appreciate it.
Thank you.
Thank you, guys. It's
Bye.
fun. We should do this again when we
Yeah.
know more.
Oh, I think we should. You're right.
Absolutely. So,
Bye.
bye-bye.
See you guys.